While often misrepresented and even misused, this right protected by the Fifth Amendment led to the famous case Miranda v. Arizona. On March 13, 1963, petitioner Ernesto Miranda was arrested at his home and taken in custody to a Phoenix police station. He was identified there by the complaining witness. The police then took him to interrogation room number 2 of the Detectives Bureau. There he was questioned by 2 police officers. The officers admitted at trial that Miranda was not advised that he had a right to have an attorney present. So Ernesto Miranda was an indigent Mexican and, according to the court, seriously disturbed. After being arrested and identified, Mr. Miranda was interrogated. The 2 interrogating officers admitted that Mr. Miranda had not been advised that he had a right to an attorney. 2 hours later, the officers emerged from the interrogation room with a written confession signed by Miranda. At the top of the statement was a typed paragraph stating that the confession was made voluntarily, without threats or promises of immunity, and with the full knowledge of my legal rights, understanding any statement I make may be used against me. Whoops. See, the form upon which Mr. Miranda had written his confession had a statement that was not true. Mr. Miranda did not have full knowledge of his legal rights, nor did he understand that his statements could be used against him. Well, all of his statements. Now, one could assume that this written confession could be used against him, but did that include anything else he said during the arrest and interrogation? At his trial, Mr. Miranda's attorney objected to the confessions, both oral and written, being entered into evidence. However, these confessions were entered into evidence, and Mr. Miranda was found guilty of kidnapping and rape and sentenced to 20 to 30 years in prison for each count. Upon appeal, the Supreme Court of Arizona upheld the conviction. In the opinion of the Supreme Court of Arizona, Mr. Miranda's rights were not violated because he never asked for an attorney. The Supreme Court of the United States, however, reversed. From the testimony of the officers and by the admission of respondents, it is clear that Mr. Miranda was not in any way apprised of his right to consult with an attorney and to have one present during the interrogation, nor was his right not to be compelled to incriminate himself effectively protected in any other manner. Without these warnings, the statements were inadmissible. The mere fact that he signed a statement which contained a typed-in clause stating that he had full knowledge of his legal rights does not approach the knowing and intelligent waiver required to relinquish constitutional rights.